So to help navigate those waters, I'm joined by 4 folks with a variety of backgrounds and experiences. And then once again, I'm going to direct you to the event website for their full biographies. But in short, please join me in welcoming Carrie Cordero, who is the Senior Fellow with the Center for New American Security, CNAS. Daniel Kahn Gillmor, the Senior Staff Technologist at the American Civil Liberties Union, or ACLU. Beta Mohanty, Public Policy Manager at WhatsApp. And Riana Pfefferkorn, Research Scholar at the Stanford Internet Observatory. Welcome to all 4 of you. Thank you so much for joining us here. I get to see you all faces at the back of the screen. So if I'm looking kind of weirdly askew, it's because you're over here and the camera's over here. So apologies in advance if I'm not making eye contact with you because I'm looking at you. So I want to dive straight into the conversation. Riana, I think I'm going to start with you actually and ask, what are, in your mind, the major milestones in this encryption debate that you would point to? I know Matt mentioned some of these earlier, but he talked about 3 crypto wars and really only dove deeply into one.
Yeah, I was happy to hear Matt's keynote because it did a lot of the work for me, at least insofar as the 90s are concerned. Arguably that was kind of crypto war 2. We could take this back further to the 1970s when professors at Stanford, Whit Diffie and Marty Hellman, together with several of their grad students, including Ralph Merkel, independently developed the concepts underpinning public key cryptography, something that had been known to the US government and I think also to the British government since World War II, but which was highly classified at the time because the Stanford group came up with the same ideas based entirely on unclassified information. You might think that that would have put them in the clear, but nevertheless, the NSA threatened to stick them in prison if they were to go forward with publishing their papers and presenting their landmark New Directions in Cryptography paper at a symposium that took place in Cornell in 1977. Ultimately, freedom of information and knowledge and academic freedom carried the day. And I'm informed that the vice admiral and director of the NSA who had threatened Professor Hellman is now friends with him later on, that they were able to get past their differences. But that was sort of the first place where it suddenly became clear to the US government that their secrets were no longer solely theirs, and that the development of commercial computers and commercial computing networks and the invention of the internet were soon going to necessitate the use of cryptography that was not solely controlled by and developed by the government. All of this is recounted in a story piece called Keeping Secrets, written for Stanford Magazine, by a then grad student named Henry Corrigan Gibbs, who's a cryptographer now, which is included in the Encryption Compendium, which you can look up there. After that, we heard the entire saga of the 90s, including both the Clipper chip and the relaxation of export controls at the end of the 1990s that previously had classified encryption as a munition, like bomb-making parts, instead classified it under Commerce Department rules instead. There are still crypto export controls in place, but it is not nearly the sort of situation that we faced in the 90s. We had sort of a quieter period after that for a while. Every so often, the FBI would float a trial balloon about trying to expand the federal laws on the books to include a mandate to add an encryption backdoor, a word I'm sure we'll talk about repeatedly during this hour, to devices or to communications services, and those didn't go anywhere. And I would say that, this whole debate kind of came roaring back when Apple announced that they were going to roll out iOS 8 in the fall of 2014, which would have removed the ability for Apple to unlock encrypted iPhones, so device cryptography for law enforcement, something that they had previously been able and willing to do. And Android soon followed suit. On the communications encryption side, we saw the rollout of Let's Encrypt, which provides a free service for encrypting web traffic. in around 2015 to 2016 in stages. And now we're in a place where the majority of web traffic is encrypted, something that was not the case a decade ago. In addition, when WhatsApp rolled out the Signal protocol in WhatsApp in April of 2016, that turned on end-to-end encryption by default for 1 billion people, something that has now grown to, I think, 2 billion people, something that I'm sure Beta can correct me on if that's wrong. And simultaneously in there, you also had the San Bernardino dispute between Apple and the FBI happening in early 2016, again, on the device encryption side. Simultaneously, we were seeing some laws start to get passed in other countries, even though the United States never got as far and has not, knock wood, so far gotten as far as passing laws that would regulate encryption and, require law enforcement access to it, and to the same degree that the UK did with the so-called Snoopers Charter in 2016, and which Australia later did with the Assistance and Access Act in 2018. So we've seen some more action on the international stage in terms of passing laws, although we did have a couple of laws passed, proposed here in the United States last summer that would have severely restricted the ability to offer what I would call strong encryption, meaning encryption that has not been intentionally weakened at the behest of any government. In 2020 so far, hopefully we won't see those come back, much less get passed. Professor Blaze mentioned in his keynote that there has been this speed up in things happening in the crypto debates. And I'm glad he said that, because when I was thinking through, what the history of these debates were, you have the 1940s and World War II and stuff happening that was classified. You have the 1970s, and then you have 1990s. And it really felt like there's a lot more going on. I wasn't sure if that was just recency bias, or because I've only been studying this area since 2015, or whether it really was that things were just speeding up. And Professor Blaze gives me some reassurance that it is in fact the case that things are just happening much faster now, and with perhaps greater ramifications for a greater number of people worldwide now than they used to back when we were just talking about the 1970s, when the military and some banks were using cryptography, and that was the only customers for this technology. But I've rambled on, so I'll pause there and let's move on.
Do anybody else want to add any key milestones that you think are important to put on the timeline? If we're like mapping out a timeline here, anything else that we should be pinging on? Daniel, I see you kind of starting to speak.
Yeah, so thanks for the overview, Riana. It's a great view of it. One thing that I want to just point out is that when we think about a timeline, we're often looking at sort of points, like this event happened here, but many of the points where policy decisions were made or things were changed actually have effects that ripple much, much longer. And I think Matt did a good job of pointing that out in his description of what would have happened had the Clipper chip succeeded. But this is something that we continually see as, policy decisions that were made, like the export controls regime, which ended more or less in 2000. The stuff pre-2000 was continuing to have an effect on the security of our communications all the way up through, 2015 was when the logjam attacks were published, which relied basically on this legacy set of crypto that everybody knew at the time was bad, that continued to be present and deployed. We're just not very good at, fixing mistakes that we've made in prompt order. So I think when we're thinking about a timeline, we really should be thinking about these bars of, something can still have like an effect many, many years down the line. And I think that's a pattern that I'm going to point out repeatedly over the course of this conversation, I think. I just wanted to flag that for folks. When you hear, such and such a thing happened, think also about what the long-term effects are.
Thank you so much. Maybe I'll turn to Carrie and ask, now that we've kind of laid out several, I don't want to keep using the word milestone, but I can't think of a synonym immediately. Maybe to talk about how, with each big event, we're seeing an evolution in thinking, both on kind of the strong encryption side, as well as the people who are thinking we are going dark and we need more law enforcement tools available to us.
Sure, thanks, Amie, and thanks for the invitation to join the conversation. It's nice to be with all of you all virtually. So I want to focus most of what I'm about to say on the law enforcement and the national security perspective of these issues. But first, just in terms of, to pick up from Riana's comments in terms of the timeline, I think one additional benchmark that we might want to put in is not so much a technological benchmark, which I think Professor Blaze's remarks were mostly focused on the technology of it. But if we want to look at legal benchmarks, 1994's CALEA, the statute that mandated telecommunications providers at the time to cooperate with law enforcement through a legal framework, has been a law that sort of permeates this entire conversation, because as the technology has changed and things have moved over to internet service providers and all sorts of other technology platforms, CALEA was never updated in the same way as the technology had moved. And so I think in terms of there having been in 1994 a congressional determination to provide a statutory framework for companies to respond to a lawful request from the lawful demand from the government in terms of a court-approved warrant or other court order, that has been a piece of the conversation that that is out there. So I would sort of put that into the timeline too, CALEA. So to focus for a minute on the law enforcement and national security equities and that part of the conversation, because that's sort of where my background and experience comes from. I went back and I want to focus kind of on the last 10 years or so, because I think there has been a shift in law enforcement and national security community and leaders' participation in the encryption debate. So if I go back, I'm gonna offer three thoughts. One is what's changed in the last 10 years. Second is, are there some fissures between the law enforcement and the national security side? And to get to the too long don't read, I think that there are some fissures there. And then three, where does that leave us in terms of a potential legislative debate? So first, if we look back 10 years ago or so, at that time, the FBI was primarily concerned about technological changes regarding real-time interception. In other words, surveillance of communications that were happening in real time. Over the course of the decade, that conversation has shifted significantly to FBI's interest in accessing data that is stored on device. So a shift in the conversation from law enforcement perspective, from the ability to intercept real-time communications to an equally, if not more significant interest in being able to access stored devices. A second sort of look back to about 10 years ago is around that time, 2011, the then FBI General Counsel was testifying in front of Congress on this issue of what the FBI has often described as the going dark issue. More recently, they've adopted language that talks about lawful access. And I've noticed a real change in terms of how law enforcement talks about this debate, which is lawful access, as opposed to using the going dark framing, which they used for a lot of years. So about a decade ago, the FBI General Counsel said that from the FBI's perspective, changes to encryption technology were not what the FBI was looking for. I think that too has changed over the course of the decade, where in more recent years, including the current and the past FBI director, the last FBI director before Director Wray, they both did talk about the ability to have a technological solution, a technological fix for being able to facilitate companies providing the contents of encrypted materials to law enforcement pursuant to a lawful request. And then the third thing, if we look back a decade ago, is at that time, the FBI General Counsel again was testifying to Congress that the FBI viewed its legal authorities as sufficient. And in that circumstance, I think that probably is sort of still true from the perspective of, I don't see the Justice Department clamoring as a policy matter for new legislative authorities, and there continues to be more of a request for working with the private sector and the technology sector to be able to come up with a technological solution that enables companies to be able to respond to a lawful request from information. I'm going to wrap up I'll pause here in a minute so others can jump into the conversation, but I would just say that from a law enforcement perspective, the fundamental premise of all of this, of all of law enforcement's arguments in the encryption debate, rests on the notion that it is a legitimate government and public interest for entities to comply with court orders. That we do have legal frameworks that allow for people to produce information pursuant to a lawful request. And that really undergirds the entire law enforcement perspective on that. So maybe I'll pause, and then later in the conversation, I'll come back to the what I see as some differences between the national security community and the law enforcement community.
Wonderful. And I'm going to take a pause myself to say it's never too early to put questions in the Q&A if you're watching virtually, but I'm going to keep going with our conversation and open it up to the rest of you. Do you have anything to add before I go with my questions to what Carrie laid out on kind of evolutions in thinking across the different big events that have happened across the different evolutions of the encryption conversation? Then Beta, maybe I'll turn to you to see if maybe you want to provide some international perspective for how these debates are not only happening here in the US, but elsewhere, and the extent those conversations might be also impacting, coming back into what is happening in the US, as well as vice versa, how what's happening here might be impacting what's happening elsewhere. We've already had Riana mention the UK and Australia, but I know for a fact those aren't the only two countries where these debates are taking place.
Thanks, Amie. So happy to be here, and thank you for convening this super important conversation. Earlier, Riana mentioned how it appears like when it comes to encryption policy, there just seems like so many things are happening right now. And I do think that the primary reason behind that is because so many people care about these issues, are affected by these issues today. Through the global pandemic and lockdown, end-to-end encryption is what has protected most people's personal conversations when it has been impossible to come together in person. End-to-end encryption is now the way that most messages are sent globally. Just to give a sense of things of the scale at WhatsApp, during the past 2 years, we've seen a huge growth in our usage. We now deliver more than 100 billion messages and 1 billion calls every day, all of which are protected by end-to-end encryption. And behind these numbers, the examples that we see of the use, we see some really sensitive use cases. Doctors, lawyers, mental health counselors, businesses, courts, and government entities all around the world are using WhatsApp more than ever to communicate privately. All of this means that the stakes for encryption have never been higher, and the threats to encryption have never been as widespread or serious as they are now. And I think the Encryption Compendium is a super important organic resource that is very useful in informing the debates that will come from here on out. And primarily because these conversations are no longer localized just to the US or to the Five Eyes countries for that matter. Some of the strongest challenges that we're seeing to encryption are coming from places like India and Brazil and the EU. And the pressures on encryption are no longer restricted to just demands for backdoors alone. We are continuing to see the more familiar exceptional access proposals. We talked about the UK and Australia, and both of them have laws in the books that give the government the authority to mandate companies to alter their systems to enable access to encrypted content. Earlier this year, Germany came very close to passing a law that would have imposed an obligation on encryption service providers to assist in the hacking of their users' communication. And right now, Belgium is actively considering a data retention law that would require the operator of encrypted systems to be able to turn off encryption only for certain users. Now, while this is super concerning, equally concerning is the emergence of, I think, two other types of anti-encryption laws and regulations that we're seeing come up around the world. And the first are the kinds that impose a duty of care or a liability on encrypted service providers that practically has the effect of breaking encryption. And this liability often rests on encrypted platforms being able to prevent harm that may occur on their platforms. And we saw this in the US with the discussion around the EARN attack. The second category of laws, one that we are very concerned with, that we spend a lot of our time trying to understand and argue against, are the laws that don't directly seek to break encryption, but propose a technical solution that has the same effect. And we've seen this happen in India with the introduction of the traceability mandate within their IT rules, which WhatsApp has now challenged before the New Delhi High Court. But we've also seen this in the debate around traceability in the Brazilian Congress over the past year. Now, what traceability does is it requires private messaging services like WhatsApp to keep track of who sent what and who shared what for billions of messages every day. That goes against the guarantees of end-to-end encryption. We have also seen an increasing push for client-side scanning to scan the content of people's messages to detect, block, and report illegal or harmful content like child sexual abuse material. The European Commission's DG Home, for example, is currently drafting child safety legislation that may mandate content scanning even for end-to-end encrypted services. And the draft UK online safety bill contemplates giving the regulator the power to mandate content scanning. Now, all of these taken together are very concerning developments. And it's important for those of us that care deeply about encryption and the ability of people to communicate privately and securely to be vocal about the problems that these sorts of laws and regulations pose. At WhatsApp, we feel an immense sense of responsibility for the more than 2 billion users that rely on our service every day to stay in touch with their friends and their loved ones. And we believe we can provide both the privacy and safety in an encrypted environment. And for that, we will continue to speak out against the laws and regulations that threaten encryption. I'll pause there, but I'm happy to circle back and talk about any of this later in the conversation.
Anything to add?
If I could jump in, I appreciate the framing that you did there, Beta, because I think the question at its core here, I know this event is about the crypto wars, but the real question that we are all grappling with is a question about communications, about control over secured communications, right? And we've seen a number of proposals, some of which you mentioned, some of which, and a number of others that you didn't mention, that they claim to not touch the encryption, but actually subvert the underlying goals. And speaking as a civil liberties and civil rights advocate, this is one of the main concerns that we have. These tools are in place, and people care about these tools, not because they care about the mathematics, although some of us care about the mathematics because they're pretty neat, but they're in place because people care about the ability to communicate privately. They care about the ability to store information privately. In the past, your communications were private by default, because you would have a communication with someone in a crowded restaurant that nobody could hear what you were saying, or you could have your conversation at home and there would be no speaker listening in. And that has shifted as more and more of our interhuman communications are mediated by these devices. The devices themselves represent a vulnerability and a chance to leak information. Private communication is really important for the social fabric, for people to be able to develop intimate relationships. And so I think that's really at the core of what these debates are about. And we say, that we've been talking here about encryption, I'll point out that there are other technical mechanisms that are in place that are part of those guarantees, those information security guarantees that people care about, whether they care about them by the name information security guarantee or not, right? Cryptographic authentication is another critical part of those pieces. And some of the proposals that we've seen weaken authentication steps. If I'm having a encrypted communication to you, Amie, but I can't tell that it's actually you on the other side, then the fact that the channel is encrypted doesn't actually save me much. I could be talking to someone else. So there's a range of mathematical structures and programmatic techniques that we talk about here, but what's really at the underlying core is this question of, can we actually be private individuals? Can we form private relationships? Can we remember things without having those memories vulnerable to extraction by someone whom we may or may not trust?
Thanks for that. I've appreciated kind of the depth of nuance that you've all brought to this conversation so far, because I think oftentimes when we talk about encryption, because it's so deeply technical and because people, especially in broader audiences, don't get into the math necessarily, we use shorthand, and we use shorthand because it's accepted and most people kind of understand what we're talking about, but we use things like backdoors or exceptional access. And those words do mean something, but they can mean a lot of things and different things in different audiences. And Carrie, I actually appreciated something that you said earlier, and I'm gonna turn to you with this question first, I think, because you referenced that there might be a divergence between specifically the national security side and maybe the law enforcement side of the communities, and those sides might not always agree. And I think that oftentimes in this simplified approach, places get grouped together. And even I oversimplified it earlier. It made me uncomfortable when I said it. I said the pro-encryption side and the side that might be saying that we are going dark. And we kind of lump them into two camps, and we say, these are the two sides, but can we get a little bit into the nuance about what are the interest groups coming at this debate? What are their interests that are at play, and what is the nuance kind of behind the arguments and the different sides?
Sure, thanks, Amie. Yeah, so this is an observation that I've had, for the last several years, at least, I think the last 5 or 6 years is what I describe as somewhat of a fissure, I think, between the national security community's perspective. So if you think about like what you might hear from an NSA director or a former NSA National Security Agency director versus what you might hear as from testimony from an FBI director who wears 2 hats himself, a national security hat and a law enforcement hat, or what you might hear from a DA, a district attorney who's responsible for prosecuting cases. So here's what I think the difference is as it has evolved over the last maybe 5 or 6 years or so. I think the national security community and national security leadership has the more probably nuanced view because they are looking at things significantly from a cybersecurity perspective. So in other words, from an ability to protect classified information, from an ability to protect the national security information they collect, the tools that they use, all of these things, they have a really deep appreciation for the value that encryption provides as a security feature. So if I put it sort of on the positive side from the national security community. So that is why I think we have not seen national security community or intelligence community leaders be on the front public facing lines of the government's going dark or lawful access conversation. I also think, and this is really just sort of my hypothesis, that the national security community is also very confident in their own abilities, so that if there were a national security need to be able to get information, they're pretty confident in their abilities to be able to do so in a national security matter. Law enforcement, pure law enforcement, on the other hand, is in a different circumstance because law enforcement is looking at cases like child exploitation, child pornography cases, which are just absolutely, there is just a huge amount of that volume of criminal activity that affects American families and families all around the world, with vulnerable victims, worst kind of possible crime. And that is an area where law enforcement has a really compelling case to make and a compelling need for information, including stored communications, to be able to solve cases. And so that's why I think we've seen the FBI directors in particular across administration. So this is not a partisan thing at all. We've seen consistently FBI directors and FBI general counsels over the last 10 years be the ones out front making this argument for why, pursuant to a court order, search warrant, et cetera, the law enforcement needs to be able to have access to information. And so they have been the ones pushing for some sort of technological solution to be able to have companies be able to provide the communications or the content of information to law enforcement to be able to solve those kinds of crimes. So I'll pause there, but that's where I see that there is some modest, but a little bit of a divergence between the way that we see the law enforcement community express its views on this issues. Also, at the state and local level, they don't have the resources of a national security agency. They don't have the technological capabilities of a national security agency or another element of the intelligence community. And so this becomes more of a really day-to-day law enforcement challenge. And just one last point on that, as a practical matter, one of the things that has changed the most in the last 5 years has been the mass deployment of encryption technology for everyday users. You know, I'm over 10 years out of government. And when I was in government handling surveillance matters for the government, this wasn't an issue. It was an issue that the FBI was working as a policy matter. And there were like working groups of people who were working on the going dark issue. But as a practical matter, everyday people, you know, all of us weren't necessarily using WhatsApp or other encrypted devices to talk with our friends, to talk with our colleagues as a matter of just basic personal cybersecurity hygiene, which we do today.
I can open that up to the rest of you. Yeah, go ahead, Daniel.
Yeah, so thanks, Carrie. I mean, you're drawing those distinctions is really an interesting point. And I think it also ties together with the CALIA point that you made earlier, right? That CALIA was a law enforcement, like a directive for the assistance of law enforcement, right? And CALIA actually changed the way our telecommunications infrastructure was implemented because it said, you know, telecom providers need to be able to provide lawful access. And so you need to build in, you know, lawful access intercept facilities in your telephone switches, right? And the impact that CALIA had, among other things, was that devices that the telcos bought all had this sort of thing baked in, right? The government basically said you have to put these features in, and those were sold all over the world, not just within the US. In 2005, a telephony switch that had these lawful intercept functions in it was actually compromised. We still don't officially know who compromised it in Greece. And actually the phones of hundreds of, or at least 100 high-level Greek officials, including the prime minister, were tapped. We don't know by who. So there were national security implications in this compromise that had been made for law enforcement. Even outside the context of the US, right, the fact that CALIA was pushing these products to have these lawful intercept functionalities meant that it could be taken over and used. That whole affair actually ended in the death, apparently by suicide, of one of the engineers in Greece, one of the telco engineers in Greece. But I think it's really worth thinking about how a goal that comes from one side, even in this law enforcement versus national security split, might end up having really potentially serious blowback in other sides.
I'd also like to maybe add in there that when we talk about, like, Amie, I agree with you that when we talk about like the government as like one unified force, that doesn't highlight the divisions and differing interests and equities in national security and law enforcement that Carrie was highlighting. But in addition to that, I would say that there is at least a third portion of government that has interests and equities here, which is the consumer protection portion of government, which is looking to the companies that are getting, leaned on in a lot of cases by law enforcement to make their users' data more accessible, to instead try and protect that. So companies are being pulled in multiple directions. On the one hand, they're producing, consumer off-the-shelf hardware and software products and services that everybody uses that may need some sort of tweaks or modifications to be used within a government or military context, for example. And so, maybe from a national security standpoint, it's better if they keep their stuff patched up. On the other hand, they may have law enforcement, saying we need to have some way of expeditiously accessing information without having to go through the third-party vendors that have cropped up as a cottage industry, such as Celebrite and Grayshift, which is now in the hands of thousands of law enforcement agencies.
Riana, can you say a word about what Celebrite and Grayshift are?
Yeah, sure. So one of the other things I neglected to mention when sort of talking about like what has shifted the encryption debate, it's been kind of responsive both to technological developments, to political developments such as the San Bernardino shooting, but those technological developments haven't only been on the defense side. If we view, Apple and Google and so forth and WhatsApp as the defenders of protecting information security, it's also been on the offensive side insofar as Celebrite, which is an Israeli company, and Grayshift, which is a US-based company founded by, I believe, a former Apple engineer, provide devices that are able to do basically digital forensics that exploit flaws that exist. Inevitably, in any software product, there's always going to be bugs that are able to exploit vulnerabilities in order to get access to and extract information from encrypted devices for the use of law enforcement. And so those are sold to law enforcement agencies around the country. We know this because of a report that was put out about a year ago by a group in DC called Upturn that used freedom of information requests and very diligently built up the ability to get back information about the number of police departments around the country that have one of these devices, which is a way of making up for what Carrie mentioned, the differing budgets that state, local, and tribal agencies may have vis-a-vis the government. The federal government law enforcement agencies also have cooperation agreements with local, state, and tribal governments through various national, regional forensics labs that are scattered around the country to provide unlocking capabilities and other technical assistance to the state and locals using sometimes these third-party tools and sometimes the things that the FBI can develop in-house, since they have significant in-house capabilities for developing exploit and that will take advantage of the vulnerabilities that occur in these things. So we see this cat and mouse game where there's the development of technologies to circumvent the technologies that had been put in place to protect information. And one of the problems that has grown up around this sort of cottage industry is that they aren't just selling to us as the good guys, and we can talk about when the good guys aren't so good. They're also selling to less rule of law respecting, human rights respecting governments around the world. And so we have this additional issue where we have third-party companies that sell, such as the NSO group, that sell their wares both to let's assume, on companies or agencies operating on a good faith basis in the United States, but also to repressive governments in places like the United Arab Emirates and Saudi Arabia, which, brings a bone saw to meetings. And so those are some, that highlights, I think, what I'm trying to get at, going back to my statement about consumer protection, which is that there are also agencies within government that are concerned with protecting the data security and the privacy of users. There is, the State Department that is concerned with protecting the human rights and democratic interests around the world. And those are all working in tension with law enforcement here, law enforcement abroad, who may not always have laws that we would consider legitimate under our democratic regime, and national security and intelligence agencies that spy on each other as kind of an accepted means of doing business, but that nevertheless means that those agencies have dual, offensive and defensive equities that they are trying to bring to bear in an environment where it is now largely the private sector that is developing and commercializing these technologies for everybody to use instead of them being, as mentioned, solely in the hands of government.
Going back for a second to your original point, your question, Amie, about what is the driving force behind some of these laws and regulations, and the outside of the national security and access to information angle, there is also the safety considerations that have been driving many of these policies. And I think underlying this entire conversation is the fact that end-to-end encryption is a technical concept that is often used in the policy conversation. And the way that it's used is to position it as something that completely obscures information and content, and therefore robs anyone of the ability to address any of the concerns that are raised, be it concerns like terrorism, child exploitation, and so on. And in this binary, often the nuance that's lost is the fact that despite end-to-end encryption, there are ways of keeping people safe. There are ways of addressing many of the concerns that drive these conversations and discussions. And the fact that you could leverage metadata, you could leverage user reports to tackle some of the kind of abuse that's the driving force behind these legislations. That's often lost in the conversation around national security and the lack of access to information.
So we talked a little bit about kind of the nuance in government perspectives. In preparing for this, one of the things I did was look back through years of my own engagement on this issue and things that I have come across. And one thing I came across was this history news items related to Symphony, which was a application used by the banking sector, which is very tightly regulated, where they consented to essentially, again, I'm going to use very simplified terms here, have a wiretappable system for communication, so that if they needed to be investigated under one of the many banking regulations, that they were able to, those investigations were able to take place. And the system was often pointed to as, look, it's workable within this sector. Why can't we have this in other sectors? So can any of you speak to, I think that the same nuance of from consumer protection to national security to law enforcement within government, do we see similar breakdowns just within the commercial sector where maybe not all sides necessarily agree on the same thing in that side as well? Stumped you all.
I mean, I think we do, right? Because different of the different private agencies, private groups have different incentives in terms of dealing with other people's data, right? We live in the cloud era where everyone's information is at some level stewarded by a number of other private organizations, right? If you have a Gmail account, Google has access to your email, right? If you are communicating via WhatsApp, Facebook has access to the metadata, at least, of who you talk to, right? And different groups have different expectations about what they can get, if they're profit driven, what their bottom line is on the information that they have, that they are effectively acting as a steward for. So you can see a different set of equities there, right? If WhatsApp's goal is to connect people to each other, and their goal is not to, say, mine the content of their communication, then WhatsApp has rightly the goal of acting as a better steward of the content of people's communication. There's no advantage to them to get information out of the content. Therefore, it's better for their users to give them stronger protections. And I think we do see some differences there among different different private groups, because some of them see their advantage as being the more information that they have about their user base, the better that is. And those are difficult trade-offs, but I definitely think you can see a spectrum across the different range of companies that offer information services.
I mean, I think just going up one level to, there's a difference between Symphony and WhatsApp, and the difference is, who the target audience is. You've pointed out, Amie, another equity that can get involved here when we talk about the interests at stake here, which is sunshine and oversight. And there are pretty good reasons for deciding that if you work in a heavily regulated industry such as banking, given the risks of insider trading and price fixing and manipulation and so forth, of course, there are reasons to decide that within that context, the public interest favors having greater oversight that includes keeping a log of people's chat messages. It's amazing how many, SEC and FINRA enforcement actions get brought against people who are still doing crimes over those exact same channels. But I think it is a folly and a fallacy to equate that to private communications between private individuals talking privately. It's as though you were to say, well, because we have sunshine laws to require open meetings among government and to have their notes be FOIA-able, we should do the same for me having dinner with my husband at home. There's simply not the same context. And it is actually a terrifying proposal to say that everybody's private communications and thoughts need to be have the same level of oversight, surveillance, and logability as those who willingly enter employment in a heavily regulated sector. So I never found the Symphony analogy to be particularly persuasive, and really just the opposite for what it was implying.
Carrie, did I also see you go off mute? I didn't want to talk over you.
No, that's okay.
I didn't want to talk over you.
That's okay. Riana started talking, but I was just gonna maybe put a little bit of a sharper point on part of what Daniel was describing a minute ago, which is that there is amongst the technology company landscape in the United States and around the world, companies monetize their users' information differently. And so, to say that in super plain language, different companies use our information to make money in different ways. And some companies put a premium on being able to provide services that provide a higher degree of privacy, and others use our information in a much more aggressive way in order for that company to make more money. So I just wanted to sort of sharpen that a little bit, because I think there definitely are differences amongst the companies that operate in this space. I think just to shift gears a little bit, I think one of the challenges for law enforcement in this debate has been the persuasiveness of the information that law enforcement has brought to the table. So when law enforcement has been trying to, sort of different law enforcement leaders over time have been trying to drive a conversation around why they need not access to Riana's private conversations about dinner, but why they need lawful access to communications between the individuals who were plotting the January 6th insurrection, has been that, which Director Wray testified about earlier this year, has been that the FBI in the past has been able to provide, Justice Department has been able to provide sort of individual case examples, but they really haven't had the data, at least that I've seen, as I from time to time, participate in these conversations with you, Amie, over the years. They haven't really brought to the table sort of persuasive, comprehensive data for how big a problem it is. In fact, about 3 years ago, the Washington Post had reported that data that the FBI director and Justice Department leaders had been using in all sorts of public statements and speeches regarding the number of phones that they had been provided by law enforcement agencies to try to crack, to use a lay term, that the stats they were using were totally wrong. And it was because of a mistake that was made. It wasn't sort of deliberate malfeasance, but it was a mistake that was made. And so the statistics that they were providing, leaders in the Justice Department were providing routinely in public statements were wrong. And so this is an observation that, I've been making and writing and speaking, for years on this, is that there just has not been persuasive enough data to drive the conversation beyond where it's been. So we can say this is a problem from a law enforcement perspective. We can say this is a problem for investigators conducting child exploitation cases, but the talking point almost ends there. I mean, sometimes it can get to the point of, and it's been this many phones, but that even doesn't really make the persuasive case. So what I, for a long time, have wished that we would see from the law enforcement community is better data, more persuasive data, research-based data that really supports the arguments for why this is a major public safety problem.
So before we turn over to some student questions we have in the room and starting to look at the Q&A, we have a question already, and this is your moment, folks, if you want to add questions into the Q&A. One last thing, because we are here to talk, in part at least, about the Encryption Compendium, to ask you all, as we look at this as a resource, how would you see something like this being useful in your work, being useful to other folks, or being useful in the future? What would be a good way, a good direction to take it moving forward for folks who might become the next generation of experts on encryption policy?
I can say I appreciate the compendium's synthesis of legal material with policy documents, with regulatory documents, with academic and cryptographic work. I think it's important to see those all as pieces of a larger overarching situation. I mean, as Matt Blaze pointed out at the beginning, he sort of broke out two initial questions that we were worried about with the Clipper chip, which was, can we trust the folks who want this access, and will the system even work? And then he had his third point, which was, if it works, what are the knock-on consequences, even if it did work, right? And those all require different types of expertise to really grapple with, and they're all tightly intertwined. You can't answer one question without another if you really want to think about what the effects are going to be on society as a whole. So I appreciate that the compendium as it stands is incorporating works from these different disciplines. I think I would love to see more specific case studies that include a little bit more technical detail, and this may be my bias as someone who is a technologist and not a lawyer. I really appreciate having the legal and regulatory frameworks in there, but there are really interesting case studies of particular types of technological change that were proposed as a fix or sneakily snuck into the public. For example, the random number generator debacle, where that we believe the NSA injected into national standards that weakened cryptography for those people who used it. I think those examples where you see a technical change interacting with a policy change, interacting with like a policy goal or regulatory frameworks, really will help to see the through lines over the decades that we've been having these conversations.
To me, I think the compendium is super useful in its comprehensiveness of just the amount of information it has about the debates as and when they happen. Something that we see in the encryption debates over the years is that every 2 or 3 years there is, a rediscovery of fire. Everyone feels like they have finally chanced upon the solution, the proposal that will finally be able to give you privacy and be able to access content and so on. And like Daniel mentioned in the beginning of this conversation, a lot of these conversations, proposals don't go anywhere, don't become codified into law, but still tend to affect the conversations that come subsequently after them. So what I think the compendium could do going forward is clubbing together some of these diverse proposals that have unique names, like ghost proposal or something else, but are essentially rehashed and repackaged same ideas that have been debunked, challenged, and negated for years on end by the civil society community, by the technical community, and so on. So that like in every subsequent conversation where these ideas are brought to light, the precedent is well established that yes, it was proposed, yes, it has been countered, no, it will not be effective.
So we have 2 specific questions. I'm going to invite them up in turn and then depart the podium so they have lots of space to come up and ask. And I believe the first one is Caden Daly, if you want to come up.
Cool. Can everybody hear me okay? Awesome. So I've heard, I guess, quite a few times over this that there has been like people alluding to potential like reconciliation or anything like that. I'm wondering if the evolution in thinking from like the 70s to now or the 90s to now has kind of helped move towards a reconciliation, or kind of like one of you just said, how the conversations don't really material go anywhere if the evolution in thinking is causing people to kind of dig into their respective positions more so and not want to compromise.
I think it moves. I think the debate moves, but doesn't ever come to an end. And so what the locuses of the discussion may shift. So it may shift from devices to messaging, for example. And it may shift from the government, or excuse me, law enforcement contending that they have no access, and that's the problem, to they can't get access quickly enough. If they grind on it, they can eventually unlock phones, or they have outside vendors. And so the point there has shifted to, well, we want to be able to get it faster, but it doesn't come to an end. I find that frustrating because in the meantime, the technology keeps progressing and keeps becoming more and more ubiquitous. And it seems like it would be advantageous if we could all just accept, that strong encryption and ended encryption are here to stay, and we need to live in that world rather than trying to roll it back. But I think that it will be difficult to find that, because if this were an easy problem, we would have solved it already at some point in the last 30 years. So I don't necessarily see this ever actually just finally being put to bed.
Thank you very much.
I mean, Riana, I think I would say in response to that there does seem to be a growing consensus that we can't stop the fact that there can be end-to-end encryption, right? Like that this sort of mathematics is, there was an attempt decades ago to make it so that the mathematics wouldn't be widely known. Now they are known, right? And there isn't like any rolling that back. And so in some sense, the debate has, it has shifted to, well, how can we cabin this thing that does exist and will exist indefinitely? And so I do think that there's been a bit of a shift in the debate where we are actually starting to have some of the debates about values instead of about capabilities. And I think it's important to recognize that there really are values at stake here. And I'd like to think that we are moving in that direction, although I do, I share your feeling that this conversation is like an undead conversation at some level.
So I'm going to invite Jonathan Stokely up to ask our second question.
Hello, my name is Jonathan Stokely. I'm a second-year Master's of Business Administration student. And I had a few different questions wanting to ask related to data privacy, trying to encrypt it, and then go to the other side of, well, think about all this data that is encrypted that potentially be used for research purposes. And then I was more kind of curious, I mean, especially the around quantum computing, and are we going to reach a point where encryption is even feasible if we have computers able to break it? So I was kind of wondering your thoughts on the latter of, I mean, in terms of encryption, are we going to get to a point of sophistication where it doesn't matter? And no matter what data or how we try to encrypt it, somebody's always going to be able to unlock it.
I can take a stab at answering that. I am not a formal theoretical cryptographer, but I've been following the quantum discussions. Quantum crypto will break many of the crypto systems that we know about today. But let me just remind you, without quantum crypto, we can break many of the crypto systems that were in use 30 years ago already. So there are new crypto systems that are being put into place that appear to be resistant to quantum crypto. And that means that things that use those new crypto systems, if the theory is correct, will be protected when quantum cryptanalysis comes along. And this is not a new situation. We've seen this situation before. It does mean that old data that was stored and encrypted with systems that newer cryptanalysis can break will no longer be protected. But in many cases, information needs protection for confidentiality for a limited time frame. Nobody really cares what the secret business dealings were going on between two different banks 30 years ago right now. And 30 years from now, the stuff that's protected with info that will be breakable should quantum computers really come on the scene may have a similar lack of interest. So this is ongoing technical work. Those of you who are there who are studying, I hope some of you will be looking into it and transitioning from one cryptographic regime to a new one, improving the strength as we go. We don't know how to do that. I work on internet standards and data storage standards, and it's very easy to see how some of those systems simply, we don't know how to deprecate old bad tools. But the technological changes work in both directions. Both the cryptanalysis and the cryptography are continuing to level up.
Thank you. Appreciate that.
Trying to mouse over from one device to another device, and you can't cross devices like that. We have 4 questions in the Q&A, and I'm going to start with Prash, who's one of our students here at the University of Colorado, and ask, is there an intention to build regulation about the metadata that's collected by private companies and make it available to government agencies? The emphasis only on getting data content might be underplaying the extent of information that can be extracted from the metadata alone. Are we over-relying on content? Metadata has so much to it. Beta, I see you're off mute.
Sure, I can start this off. I don't think there are efforts right now to directly start sharing the metadata that companies collect to governments, and I hope there isn't. That being said, I do think that metadata is significantly useful for preventing the kinds of abuse that is often of interest for law enforcement and detecting and dealing with abuse. So I agree with the sentiment that there is an over-reliance of content in these regulations, in these anti-encryption calls, because there is so much that we can already do with metadata to prevent abuse, to tackle abuse that we see on our systems. WhatsApp bans around 300,000 accounts each month for suspected sharing of child sexual abuse material. We make 400,000 reports to NCMEC about about individuals that we suspect share child sexual abuse material. And all of this information, all of this dealing with abuse happens on the basis of information that's shared to us by users, like user reports, or from metadata like profile pictures, group profile pictures, group information, and so on. So there is a significant role that metadata has to play in dealing with abuse. So it is true that there is an over-reliance on content in anti-encryption laws and regulations. But at the same time, I don't think there should be any requirement or calls for the direct sharing of metadata from the companies to the governments. I think that would be setting us back quite a bit.
So another one we have in the debate, we often hear these companies scan communications for malware anyway. What's the difference? Is there a technical difference between general monitoring of communications content for systems reasons versus monitoring content for illegal content? Or is the difference only in the acceptance of why?
I think, I can let others speak to whether there is a technical difference. I think certainly in terms of purpose, there is a stark difference between monitoring somebody's, doing a virus scan or a malware scan for reasons that are intended to protect the user versus turning that system against the user to try and look for illegal content or simply disfavored content, whether or not it is illegal. And I think that gets to some of the crux of a lot of the discussions around client-side scanning and around scanning in the cloud for reason A versus for reason B. And so, I think you have an easier time selling to people having a system that is solely trying to keep them from having their data security and privacy compromised, as opposed to having their free expression and other privacy interests affected by the same system turned to a different purpose.
I think Riana is really on point there, that the purpose is, there are minor technical differences or maybe big technical differences, but really the purpose is the question. And I think another way of looking at that is to say, does your telecommunications equipment work for you or does it work for someone else, right? And the devices that most people today carry around with them are very intimate devices. These are devices that know not only your location and your interests and your hobbies and your relationships, they know just a tremendous amount about what you do. You offload your thoughts into them many times. And if that device, which is effectively being used as one of your main ways of interacting with the world, is not working for you, there's a real significant problem there, right? It means that people are sort of having parts of themselves co-opted to work against themselves.
Great, I saw you go off mute also. Do you want to add?
Sure. I think there's two questions contained in this one, and which is why the answer is yes and no. I think when it comes to monitoring for malware or the systems-wide problems for scams, spam, and so on, I think there is a technical difference between what the company has observed. There, the focus is on behavioral patterns that can help identify, some kinds of abuse, and those are content independent. So I think there is a technical difference between that and the scanning of content. And the problem comes when we start talking about the scanning of content, and there Daniel was exactly right. Their values come into play. What is it that you're scanning for? And what is that information that you've provided this company that you somewhat trust? Like, who is that company then working for? Are they doing it only to protect you? Or are they doing it to potentially notify you to law enforcement and so on? And I think I don't think there is a technical difference between scanning for only one kind of content versus another kind of content, which is why these proposals are problematic, because they might say that this is restricted to CSAM, but there might not be any way of ensuring that the scanning is only meant for one kind of content and not any other kind of content that is decided by the company or the government.
So John Callis asks, I'm curious about some of the debate about lawful access, and is there anything that a person can keep secret? Are there any limits on what a warrant can require to be produced? I've heard law enforcement people say there is not, as a warrant is a requirement for them and they'll be punished by judges if they can't find things. Carrie, I think this goes to something you said earlier, if you want to start.
Sure. So, so warrants are issued by a judge based on facts that government investigators provide of evidence of criminal conduct. So if I keep it in the law enforcement side, set aside national security for a minute, just in the law enforcement conduct, when if an investigator, a federal investigator is going to a judge with a search warrant, they have to have facts that establish probable cause that a crime is being or is about to be committed. And then we get into the details of which crime is potentially being committed and what the facts of the investigation have. But that is, a fundamental premise of what law enforcement is trying to communicate in this debate, which is that they are not interested in everyday people's communications or trying to get access to those communications. What they want to be able to do is solve crimes, disrupt criminal behavior, and bring individuals who are committing crimes to justice. And that is a fundamental premise of our civil society. So, I'll pause there. I hope that answers the question in terms of, yes, they're not interested in getting information about every individual person. What they're trying to do is law enforcement is trying to do is focus their activities as it pertains to their mandate to solve crimes, help victims, and prevent future activities. And then we can get into sort of the domestic terrorism and terrorism side of things, which on domestic terrorism, it spans the law enforcement and national security side. And then there's international terrorism activities as well, where in addition to solving crimes and disrupting them, which the mandate for law enforcement agencies and national security agencies is to try to prevent the actual act of terrorism, whether it's domestic terrorism or international terrorism. But all of those, if the investigator is presenting evidence to a judge to get legal authority under a statutory framework that has been approved by Congress, is in the construct of a lawful request for lawful demand for information that's premised on facts.
So I feel like John's question might be more about what sort of limits would law enforcement be willing to accept on a scheme that would allow them to bypass some of the information security features that encrypted communications offer. And this does come up when we're in past conversations that I've had where people are gaming out different technical proposals to provide encrypted communications that maybe provide some lawful access as well. Often the technical designers say, well, what would you be willing to accept a situation that would only let you unlock 100 devices in the course of a year? Or as Riana mentioned earlier, would you be willing to accept it costing you 4 days to unlock a device instead of it being an instantaneous unlock? Or would you be willing to submit to a certain type of oversight regime, which requires that you list all of the devices that you've unlocked, maybe with some limited time delay? And I think this question about what limits would law enforcement be willing to accept, in exchange for giving some ground on the crypto systems, whether that's possible or not, is a really interesting one, because my experience has been that every proposed limit, whether that's, well, we wouldn't, we can, let's say, maybe the people on this call would disagree, but I'd like to think that we could all agree that a warrant for someone's thoughts would be considered out of bounds, right? That's a piece of content that I'd like to think we could all agree as a society are out of bounds for police access, regardless of whether there's a warrant or not. And maybe there are techniques that are out of bounds, right? Like we wouldn't say you can get a warrant to melt through the structural members of someone's house in order to find out whether they in order to find out whether they have a marijuana inside, right? There are things that should be limits, and if we're talking about how can we deal with a crypto system in the context of law enforcement, there is an open question. This goes back to the values point that we were talking about before, of what limits would law enforcement be willing to accept in terms of things that they can access. In the past, they have not been able to access things, and I don't believe I've ever heard of any story of a law enforcement being punished by a judge because they were unable to reconstruct someone's conversation in a pub back before there were microphones in everyone's pocket in a pub. They simply, they got a warrant to go and ask people if they knew anything. When people didn't know anything, that was it. It's not a failure to be unable to produce information from a warrant. So I think that the idea that people have been punished is also an interesting question. Like, I don't know what those punishments are.
We could probably go on for another hour, but we are at time. Thank you all so much. I wish I could get more of your thoughts, but I appreciate you joining us. We're going to go into our last keynote. Thank you for your time. Thank you for your thoughts and for taking time to share those thoughts with both of those of us in the room, those of us joining virtually. I hope you'll tune in for the last keynote, and I look forward to continuing this conversation either online or in any other format. We shall continue discussing with everybody. Join me clapping in the room. We can still clap. And we'll transition over